Welcome to the deep dive. Today, we're really getting into the foundational stuff for family law in England and Wales. If you're a student tackling this subject, well, this session is definitely for you. We're going to unpack some really crucial introductory ideas. And this comes straight from the source material that's been generously made available by the University of London for their students. Just a quick heads up, this deep dive is brought to you by Sinorbit Academy, Sri Lanka. It's purely for educational purposes, okay? Based strictly on that University of London material. It's definitely no substitute for, doing your own reading and hard work. Now, speaking of hard work, if you are gearing up for exams in family law, seriously, the very best of luck with your studies. It's a big subject, but you can do it. Hopefully this helps you get started.
Absolutely. What we're looking at today is that essential first look, like the roadmap you get right at the beginning. We'll touch on what family law actually covers, why it's, well, so incredibly important, and crucially, how this introductory material suggests you approach studying it. It's about getting your bearings, really, before you dive into the specifics.
Exactly. So our mission today, pull out the most important bits, those core ideas, and walk you through the key concepts, the resources you absolutely need, and yeah, those vital tips for tackling exam questions, all coming from this introductory guide.
Think of it as laying the groundwork. Let's start with just how relevant family law is. It's not some niche topic. It really does touch almost everyone's life at some point.
Okay, let's unpack that then, the relevance and scope. You say it touches everyone. Why does this area matter so much to individuals, adults, children? What makes it so fundamental?
Well, fundamentally, family law is the part of the law that regulates those interpersonal relationships we consider familial. Relationships formed by marriage, by civil partnership, or simply by being someone's parent. And the consequences of these relationships, well, they're huge. For the individuals, yes, but also for the state, for society. It structures major life events.
So it's the legal scaffolding around our closest connections. The source material lists some core areas it covers. What are they?
Right. The guide mentions, first off, the establishment of marriage. So the legal rules, the procedures for actually getting married.
Yeah, how marriage starts.
Then, naturally, the dissolution of marriage, what we usually call divorce, the processes, the legal consequences when a marriage ends.
Marriage, divorce. Seems logical. What else in terms of adult relationships?
It also covers the legal consequences that come from both marriage and cohabitation, just living together without being married or in a civil partnership. That's a big one.
Cohabitation. Yeah, that's always complex, the difference in rights.
It is. And the law does regulate certain aspects, especially if there are children or when the relationship breaks down, even if they weren't married.
Okay. What else?
Then you've got civil partnerships, both how they're formed and how they're dissolved. They offer a formal legal status, originally for same-sex couples, now for different-sex couples too, with many similar consequences to marriage.
Right, civil partnerships. Almost parallel to marriage in many ways now.
In many ways, yes. And finally, the guide mentions the legal regulation of domestic abuse. This is crucial. It's not just criminal law. Family law offers protective orders, remedies for people facing abuse within these relationships.
Starting relationships, ending them, living together, protection from harm. That's already a lot. But you mentioned the material really highlights children.
It really does. This is a key takeaway. The guide states very clearly that a huge portion of the syllabus, 50%, half of it, is dedicated specifically to the law relating to children.
50%, wow. Okay, so half your study time, potentially half the exam.
Mm-hmm.
Is about children.
Exactly. It underscores how central children are. It's not just another topic, it's half the subject.
So what are the core issues within that massive area of children's law that the introduction points to?
Okay, the main concerns are pretty fundamental. First, the status of a child, how the law defines and treats young people. Second, determining a child's parentage who legally counts as the parent. Huge implications there for rights, responsibilities.
Status, parentage. Makes sense.
Third, and this is increasingly important, the rights of the child themselves. Moving away from just seeing children as needing protection towards seeing them as individuals with rights.
That feels like a significant shift, acknowledging children's own rights.
It is, yeah. Reflects wider changes, international conventions linked to that. Fourth is the child's welfare. This is the paramount consideration in many decisions about children, the welfare principle.
A welfare principle. Okay, that sounds like a cornerstone concept.
It is. And finally, the syllabus covers the powers of the state regarding children. Think local authorities, court interventions when there are concerns about safety, neglect, abuse. A very complex and sensitive area.
Right. Status, parentage, rights, welfare, and the state's powers.
Yep.
That's a huge field in itself.
The material also hints that studying family law isn't just about rules. It connects to wider societal issues. Religion, politics, values.
Oh, absolutely, because it deals with how we structure our personal lives, how we
Right.
form families, raise kids. It's constantly interacting with our social norms, our ethics, our political debates. Think about debates on same-sex marriage, surrogacy, cohabitance rights. They're all rooted in social values about what relationships the law should recognize, right?
Yeah, you see those headlines all the time.
So studying family law gives you this fascinating window into how law reflects society, responds to change, sometimes even drives change. It's not dry, it's alive, connected to everything.
That definitely makes it sound more engaging. And while this course focuses on England and Wales, the guide notes the basic challenge law engaging with personal lives is universal.
It really is. Every legal system grapples with defining family, regulating relationships, protecting children, dealing with financial consequences. The specifics differ, but the core questions are the same everywhere. England and Wales is just one approach.
Okay, so we've got the scope, the relevance. Now let's get practical for students. Resources. The guide warns family law moves fast. Old books are risky.
Very risky. The law changes so often, new acts, new big cases, policy shifts. An outdated textbook means you could be learning law that's just wrong. Bad for understanding, terrible for exam.
Right, so what's the top recommendation? The go-to textbook.
The core text, the one the guide really flags, is Herring J. Family Law, specifically the 10th edition, published in 2021. That's stated as the most up-to-date and appropriate.
Okay, Herring, 10th edition 2021. Got it. Jonathan Herring. Is that the only option or are there others?
No, the source lists several other suitable ones. It acknowledges different styles suit different people. Books by Davy, Didak and Kaganes, Gilmore and Glennon, Harris Short et al., Lamont, Lowe et al., Morgan, Probert and Harding, noting the old Cretney and Probert connection there, and Wellstead and Edwards. But crucially, the specific reading references in the module guide itself are based on the editions listed in that guide.
Right, so Herring 2021 is the main one, but others are fine if you use the specified editions. What if, say, you can only get hold of a newer edition of one of those books?
That can often be fine, maybe even better for keeping current if it's much newer. But, and this is a big but, the page references in the module guide won't match up anymore.
Ah, okay, so how do you navigate that?
The advice is clear. Use the detailed chapter headings, the section headings within the book, and especially use the index. Find the readings for the topics listed in the module guide using the book's own structure, not the page numbers from the guide.
Makes sense. Use headings and index for newer editions. What about staying up to date generally? Is there one key resource?
Yes, the virtual learning environment, the VLE. This is absolutely critical. Updates to readings, new cases, legislative changes, specific guidance for your year, it all goes on the VLE. You have to check it regularly.
The VLE is your lifeline. Got it. So, core text, Herring 2021, maybe others, check editions. Navigate newer editions carefully. Constantly check the VLE. The guide also says read widely beyond the textbook.
Yeah, it encourages using the VLE resources, the online library, legal databases, maybe even quality news sources. It helps you get different perspectives, understand the debates, see how the law works in practice. The guide explicitly says, think about how principles apply in the real world. Wider reading helps that.
Real-world application feels key here. Now, the exam, the statute book, that's going to be vital. What are the rules?
Okay, this is super important and non-negotiable. You can take one authorized statute book into the exam. One.
One authorized book. How do you know which ones are authorized?
You must check the current regulations for your specific program. They list exactly which statute books are permitted. Don't guess, check the regulations.
Check the regulations for the approved list. Got it. And markings inside the book. Can you scribble notes?
Absolutely not. No notes. You are allowed to underline or highlight text. That's fine and very useful. But no writing, no comments, no sticky notes with writing, just underlining or highlighting.
Underline or highlight only. Clear. What about the edition?
Get the latest edition you can. Family law statutes get updated, things change. You want the most current version of the law in there with you. So, latest edition of the authorized book.
Okay, summary. One authorized book. Check regulations. Underline, highlight only, no notes. Latest edition, that's crystal clear. What about other books like specialist texts or journals mentioned? Need to buy those.
No, not required purchases. But journals like Family Law or Child and Family Law Quarterly are valuable for deeper dives. They have articles on new cases, reforms, academic debates. You can usually access these through the online library. Great for enriching understanding, especially for essays.
Good tip. Supplementary reading via the library. The guide also lists loads of websites. Can we run through some key ones?
Yeah, these are really useful. For primary sources, cases, and statutes, www.bailii.org. That's BAILIII.org. Free access, incredibly useful, especially for recent higher court judgments.
Bailey I. Essential. What about the profession?
www.flba.co.uk Family Law Bar Association for barristers. For children's issues specifically, www.cafcas.gov.uk. That's the Children and Family Court Advisory and Support Service, a really key organization. And www.childrenscommissioner.gov.uk, the Children's Commissioner for England.
FLBA, CAFCAS, Children's Commissioner, practical stuff like child maintenance.
www.resolution.org.uk. That's Resolution, used to be the Solicitors Family Law Association. They push for less confrontational approaches.
Resolution, good to know. Government sites?
Yep. www.homeoffice.gov.uk for things like domestic abuse policy. The Law Society's family section at www.lawsociety.org.uk topics family and children. And the main government portal, www.goods.uk, has sections on marriage, divorce, etc. Just browse under births, deaths, marriages.
Home Office Law Society, gov.uk. And finding the actual laws online.
www.parliament.uk is good for tracking new laws, finding Lord's judgments quickly, Hansard debates, but for the definitive up-to-date text of acts, www.legislation.gov.uk. That's the official database. Really important.
Legislation.gov.uk. Vital for current statutes. And keeping up with news.
www.familylawweek.co.uk. It's an updating service, good for tracking recent developments.
Wow, okay, that's a toolbox right there. Knowing how to use those online resources seems just as important as the textbook.
Absolutely. In a fast-changing field, knowing where to find current, reliable information is key.
Which leads perfectly to managing study time. The guide admits the family law syllabus is, well, huge and varied.
It really is. Marriage, divorce, money, domestic abuse, plus that massive 50% on children. Lots of different bits, each with its own rules.
So, trying to cram this the week before the exam, probably not going to work.
Definitely not. The material stresses you need to set aside proper, dedicated time each week, right from the beginning. Consistency is vital.
And the guide suggests different topics need different amounts of time.
Yeah, it gives examples like the formalities of marriage, while important, probably need less time than, say, the whole law of divorce or financial provision after divorce or domestic abuse law. Those are much bigger, more complex areas.
And the children's law part, given half the syllabus.
Exactly. That needs a major time allocation. The guide says 50% is children's law. And even within that, some bits are heavier than others. Things like the welfare principle or children's rights might be quicker to grasp than, say, the detailed court orders for upbringing, or especially the powers of local authorities regarding children. The guide calls that a large and complex subject.
Okay.
Similarly, things like wardship, while part of the syllabus, usually take less time than understanding those extensive local authority powers.
Right, so the takeaway is plan your time, look at the syllabus breakdown, see that 50% for kids, identify the big, complex topics like divorce, finance, and local authority powers, and give them the time they need. Don't treat all topics equally in your schedule.
Precisely. Plan based on the weight and complexity indicated. And while weekly study is key, the guide does say ramp it up in the last 6 weeks before the exam. That's consolidation time.
Final push, but built on steady work. The material also says study time is personal, right? What clicks for one person might not for another.
Absolutely. The real test isn't hours spent. It's whether you know the topic thoroughly. Can you explain it? Can you apply it? Stop only when you're confident. Planning carefully for your needs is key.
And linking back to consistency, continuous revision. The guide really bangs this drum. Don't leave it all to the end.
You just can't, especially in law. You need to keep revisiting topics. It embeds the knowledge, keeps it fresh, and crucially helps you see the links between different areas. That's vital for exams.
Makes total sense. Learn, revisit, connect. The guide also recommends a specific way to use the module guide itself with the textbooks. What's that method?
Okay, it's a structured approach. First, read the relevant chapter of the module guide. This gives you the overview, the key issues, the map for the topic.
Guide first for the overview.
Then, critically, read the textbook covering that topic. The guide is not a substitute for the textbook reading. The detail, the depth, the case analysis that's in the books.
Guide for map, textbook for detail. After reading.
Go back to the module guide and do the activity questions. The guide stresses doing as many as you can. They make you apply the law, test your understanding. They're active learning.
The activities are where you check you've actually got it.
Exactly. And importantly, use the feedback provided for the activities. See where you went right or wrong, why, and what you need to look at again.
Okay, that structure guide, textbook activities, feedback sounds like a really solid way to work through each topic.
It is. It builds knowledge systematically and checks you're absorbing it. Follow that pattern.
Right, let's switch focus now to something really fundamental and quite fascinating raised in the introduction. The whole idea of family law and how the law decides what counts as a family.
Yeah, this is core. Because the law often gives special rights or imposes duties based on family relationships, it has to decide who fits that label, and it's not straightforward.
Why does the definition matter so much legally?
Because, as the guide points out, big consequences hang on it. Benefits, burdens. Think inheritance rights, tax breaks, or the example given, housing law protecting family members of a tenant who dies. The law must decide who qualifies in those cases.
And drawing that line has been tough historically.
Yeah.
The material mentions an old case, Blackwell v. Bowles.
Yes, Blackwell v. Bull, way back in 1836. Even then, the court saw that family is a super flexible word. It could mean the household, wife and kids, just kids, the whole bloodline. The key takeaway from Blackwell v. Bull was that you have to look at the context, the purpose of the law to interpret family appropriately. It's not fixed.
So nearly 200 years ago, they knew family wasn't one size fits all. How do modern courts handle this, like in that housing example?
The material points to Sefton Holdings v. Cairns from 1988. The approach there was to look at the relationship's circumstances and ask, what would an ordinary person characterize the relationship as?
The ordinary person test. From Sefton Holdings v. Cairns, 1988. That's interesting. It implies the legal definition can shift as society's views change.
Exactly, and the guide links this directly to the law, increasingly recognizing relationships like unmarried couples, same-sex couples, and their children. The law is, sometimes slowly, trying to catch up with how ordinary people see family.
This evolution is really shown in the landmark case, Fitzpatrick v. Sterling Housing Association, right?
Fitzpatrick v. Sterling Housing Association, yes. A massive case from 1999. In that housing context, again, this was the first time a same-sex partner was legally seen as having that necessary familial link to get statutory protection.
So, Fitzpatrick v. Sterling Housing Association, 1999. First recognition of a same-sex partner having that familial link for legal purposes. Huge step.
It was huge. And the guide includes some really powerful quotes from the judges. Lord Slynn pointed out that courts hadn't found one single ingredient for a family link, reinforcing that ordinary person view based on circumstances. He said, and this is key from the judgment, I hold that as a matter of law, a same-sex partner of a deceased tenant can establish the necessary familial link. But he stressed, a transient superficial relationship will not do. Mere cohabitation by friends will not do. It had to have substance. He added it recognizes two people of the same sex can be regarded as having established membership of a family, which both gives benefits and imposes obligations.
That quote from Lord Slynn sets a standard, doesn't it? It's not just living together. It's about stability, permanence, commitment, like a traditional family structure, but applied more broadly.
Exactly. And Lord Nichols made a similar point very powerfully. He said if a stable, permanent sexual relationship between a man and woman counts as family for legal purposes, then there's no rational or other basis to deny that for a similar relationship between two men or two women.
That's a clear equality argument based on the relationship's nature, not the partner's gender. Those quotes from Lord Slynn and Lord Nichols and Fitzpatrick really show the courts grappling with change and applying that ordinary person idea.
They show the judicial process responding to society.
This talk of evolving definitions and equality leads straight into the next big theme, the impact of human rights law.
Yes, human rights principles, especially from the European Convention on Human Rights, the ECHR, have really shaped modern family law in England and Wales. The guide uses Gaidon v. Godin-Mendoza from 2004 as a prime example.
Gaidon v. Godin-Mendoza, 2004. What was the issue there?
Again, it was housing rights. Under the Rent Act, 1977. The act gave some rights to surviving same-sex partners, but fewer succession rights than heterosexual partners got. It was clearly discriminatory.
And how did the House of Lords handle that discrimination in Gaidon?
They found it wasn't justified. Crucially, they said it infringed Article 8 and Article 14 of the ECHR.
Article 8 and Article 14 ECHR. Remind us what they cover.
Okay, Article 8 ECHR is the right to respect for private and family life. Its broad covers personal autonomy, relationships, home. Article 14 ECHR is the non-discrimination principle. It forbids discrimination in how the other convention rights, like Article 8, are applied. So the argument in Gaidon was that the Rent Act treated same-sex partners differently regarding their family life, Article 8 without justification, violating Article 14. So that's ECHR, Article 8, private family life, and Article 14, non-discrimination.
Right, Articles 8 and 14 working together. How did the court actually fix the discriminatory law? They couldn't just rewrite the act, could they?
This is where the Human Rights Act 1998, the HRA 1998, comes in, specifically Section 3 of the HRA 1998. This requires courts to read and interpret legislation as far as possible in a way that's compatible with ECHR rights. The House of Lords used HRA 1998 Section 3 to interpret the wording of the Rent Act. They essentially read it as if it did provide equal rights, even though the original text didn't explicitly say that. They stretched the interpretation to make it ECHR compliant.
So the Human Rights Act 1998, particularly Section 3, gave the court the power to kind of update the meaning of older laws to fit with human rights standards like ECHR 8 and 14. That's a big deal.
It's a very significant power. It allows courts to address incompatibilities without waiting for Parliament to legislate every single time if the wording allows for a compatible interpretation. And the material notes that since Gaidan in 2004, Parliament has acted more directly.
Yes, with the Civil Partnership Act 2004 and the Marriage Same-Sex Couples Act 2013, those created formal legal structures.
Exactly. Cases like Fitzpatrick and Gaidan helped pave the way for that legislation, which gave much broader recognition. So remember those acts: Civil Partnership Act 2004, Marriage Same-Sex Couples Act 2013, key milestones.
Going back to Article 8 ECHR, respect for private and family life, the material says it raises tricky questions for courts.
It does. Like, which relationships actually count as private or family life? It's not just marriage. What does respect actually mean? Is it just leaving people alone, or does the state sometimes have to do something positive? And does Article 8 mean all types of family relationships have to be treated exactly the same?
Difficult lines to draw. The European Court of Human Rights in Strasbourg, the ECTHR, has looked at these.
Yes, several cases are mentioned. Schalk v. Austria in 2011. The ECTHR agreed that a committed long-term relationship between two men did constitute family life under Article 8, deserving protection.
So the ECTHR confirmed in Schalk v. Austria that committed same-sex relationships are family life for Article 8.
And that was reinforced in Valianatos v. Greece, 2013. Then Oliari v. Italy, 2015, went further. The ECTHR found Italy violated Article 8 by not providing any way for same-sex couples to get legal recognition, suggesting Article 8 might sometimes require states to create a legal framework.
Valianatos reinforcing the right, Oliari suggesting a positive duty. Shows human rights driving change. But does this mean all family relationships must be treated identically? What about Burden and Burden v. UK?
Ah, yes. Burden and Burden v. UK, 2008. This is the counterexample. Two elderly sisters lived together their whole lives, owned property jointly. They argued it was discriminatory under ECHR Articles 8 and 14 that they faced inheritance tax differently than a married couple or civil partners would.
What did the ECTHR say in Burden?
They said no, it was not unlawful discrimination. Their reasoning was that marriage and civil partnership involve a specific type of legal commitment and interdependence that is fundamentally different from a sibling relationship, however close. So, the state could treat them differently for tax purposes. Burden and Burden v. UK is key. It shows that different types of close or family relationships can be treated differently by the law for specific reasons, and that might be compatible with human rights.
That's a really important clarification. Family law doesn't have one definition of family. It applies everywhere. It looks at the specific issue and the relationship type.
Exactly. The guide sums it up well. Family law is less about abstract definitions, more about specific issues arising in family life and their legal consequences. Sibling relationships might be recognized for, say, domestic abuse protection, but not usually for financial support obligations, which tend to focus on spouses, partners, parents. These distinctions matter and will come up again and again.
A very practical, context-dependent approach. And the material just notes in passing those ongoing talks about maybe replacing the Human Rights Act 1998, though nothing's confirmed.
Just another reminder that things can change, even the legal framework itself.
Okay. Scope, resources, study time, defining family, human rights impact. The introduction also clearly spells out what's not covered. Knowing the boundaries seems just as important.
Absolutely. Helps you focus your study. Don't waste time on excluded topics.
So it's definitely out of this syllabus.
First, the law on inheritance and family provision on death. What happens with property when someone dies that's usually covered in succession or trusts? Not this family law module.
Inheritance is out. What else?
Second, detailed family property law concerning implied, resulting, and constructive trusts, and related property statutes about improvements. While financial settlements on divorce obviously involve property, the complex trust law principles determining underlying ownership outside that context are excluded.
So core equity and trusts, concepts like constructive trusts, even between family members, are not the focus here. Good to know.
Correct. The guide also hints that some niche topics within the main syllabus areas might be rarely examined and get less attention in the guide. You'll get a feel for that as you study.
Okay, some de-emphasis possible. And it assumes some prior knowledge.
Yes, basic familiarity with the English court system, magistrates, county, high court, etc., and their family roles is assumed from studying the English legal system previously. They don't reteach that structure.
Knowing what's out helps manage the workload.
Definitely. Focus your energy where it counts.
Which brings us to the exam itself, probably top of mind for students. The material gives practical advice here.
It does. And it starts with the golden rule. Always check the current regulations for your specific program, always check the VLE for updates, and always check the rubric on the actual exam paper itself. Rules can change. Get the latest info.
Regulations, VLE, paper rubric. Triple check. What's the general format?
Usually 3 hours and 15 minutes long, and typically you answer 4 questions out of a choice of 8.
4 questions in 3 hours.
Yep.
Okay, we talked about the statute book rules already, but maybe a quick recap as it relates to the exam.
Worth repeating. For the exam, 1 authorized statute book. Check the regulations for which ones are allowed. You can underline or highlight text. You absolutely cannot write notes in it. And get the latest edition possible.
1 authorized book, check regs, highlight, underline only, no notes, latest edition. Got it. And the VLE has other exam resources.
Yes, crucially, past exam papers and, even better, the examiner's commentaries on those past papers. These commentaries are gold dust. They tell you what examiners liked, common mistakes, how to approach questions. Use them.
Examiner's commentaries, definitely seek those out. Okay, the exam has both problem questions and essay questions. Different skills needed.
Totally different skills. You need to be good at both.
Let's take problem questions first. What skills are key there?
For a problem question, the scenario type you need to show you can. 1, spot the right area of law. 2, pick out the legally relevant facts. 3, identify the legal issues those facts raise. 4, apply the statutes and case law to those facts to sort out the issues and advise whoever needs advising.
Identify area, facts, issues, apply law. Standard legal method. But family law can be a bit unpredictable due to court discretion.
That's true. Especially with children or finances, judges have discretion. Similar facts can lead to different outcomes sometimes. But your goal in the exam isn't perfect prediction. It's to use the case law sensibly, show how courts usually handle these things, discuss the relevant principles and factors. If asked to advise X, show you understand the legal hoops X has to jump through, the arguments, the likely considerations. Focus on the legal reasoning.
So demonstrate the legal analysis, not guarantee the outcome. Case law is obviously vital for that.
Absolutely critical. The guide stresses careful note-taking of key cases, facts, principles throughout your studies. That's your revision foundation.
And there's that specific warning about citing re-X cases accurately.
Yes. Highlighted as a common mistake. Lots of anonymized children cases are just re plus a letter and year, like re-W 1999. But there might be several re-W cases from 1999.
So just writing re-W 1999 isn't enough.
Not enough. You need the full title, usually with a subheading in brackets to distinguish it. The guide gives examples: re-W contact, parents' delusional beliefs, re-W residence, re-W disclosure to police, all different 1999 re-W cases.
Ah, right. So pay attention to the full name, including things like contact or residence, to be precise, especially with those common letter cases like re-W. Crucial for clarity.
Crucial. Shows you know which case you mean. Start noting them properly from day 1.
What about statutes and problem questions? Lots of acts in family law.
Very statute heavy, but the advice is do not copy out long chunks of the statute in your answer. Examiners know the law, you have the book.
So what do you do?
Briefly cite the section number, like S11, Children Act 1989 says, then immediately interpret it and apply it to the facts of the problem. Show how that specific law affects these specific people in the scenario.
Cite, interpret, apply. Much better. How do statutes and cases work together in problems?
Statutes give the framework, the powers, procedures, main tests, like the welfare principle. Then key cases establish the big principles for how courts use those powers. And then lots of other cases illustrate courts applying those principles in different situations.
So statute skeleton, key cases, muscles, other cases, examples of movement.
Good analogy. Know the statutes and the key principle cases inside out. Reading the example cases deepens understanding of discretion, but you don't need to memorize every single one.
The guide gives a very useful checklist for tackling problems, especially children cases. Can you run through that?
Yeah, it's a great structure. Ask yourself, 1, what's the legal position now? before any court order? Who has parental responsibility? What's the status quo? 2, what court orders are available? What do they actually do legally? 3, who can apply for them? Is there a procedure? 4, what are the statutory criteria the court uses? Does the welfare principle apply? Does the welfare checklist in the Children Act apply? What are its factors? 5, what does case law suggest about how courts use these powers criteria? Is there a typical approach? 6, practicalities. How long do orders last? How are they enforced?
That checklist is brilliant. Current position available orders, who applies legal tests, like the welfare principle checklist, case law guidance, duration enforcement, covers all the bases.
It really helps structure your answer logically and make sure you don't miss anything vital.
Okay, shifting to essay questions. Different beast entirely. What's the main thing examiners want here?
Critical, well-argued evaluation, not just describing the law. You need to understand it and then analyze it. Strengths, weaknesses, policy, reform arguments.
Understanding plus critical evaluation. The guide gives another checklist for structuring that evaluation.
Yes, questions to ask yourself about the law you're discussing. 1, why is the law like this? History, policy aims. 2, does it cause problems? Unfairness, difficulties. 3, would changing it create new problems? Downsides of reform. 4, is its policy consistent with modern views, other laws? 5, is it consistent with human rights or international standards? 6, on balance, is change needed, or is the current law the best compromise?
That essay checklist, why? Problems. Problems with change. Consistency, human rights. Balanced conclusion provides a great framework for critical analysis.
It helps you move beyond description to proper evaluation. But there's a crucial warning.
Which is?
Your brilliant analysis must answer the specific question asked. Don't just write everything you know about the topic. Target your argument directly to the question on the paper. Relevance is key.
Answer the question. Fundamental exam advice. Always. Lastly, the introduction ends with a list of abbreviations. Why flag these up front?
Because you'll see them constantly in the guide, textbooks, cases, articles. Knowing them makes reading much faster and smoother. Things like CA, MCA, HRA, ECHR.
So it's about fluency. Any particularly key ones from the list provided to get a handle on early?
Definitely review the whole list in the guide. But yes, you'll see CA, Children Act, usually 1989, CPA, Civil Partnership Act, ECHR, European Convention on Human Rights, HRA, Human Rights Act, MCA, Matrimonial Causes Act, all the time.
CA, CPA, ECHR, HRA, MCA, the big statutes in the convention.
Exactly. And for journals, CFLQ, Child and Family Law Quarterly, and Family Law. Knowing these just makes navigating the literature so much easier.
CFLQ and Fam Law. Okay. Getting those abbreviations down early sounds like a smart move.
Small effort, big payoff in study time.
Wow. Okay. We have covered a lot just from this introductory material. We've looked at the huge scope and relevance of family law, that massive 50% focus on children. We've mapped out resources, Herring, the VLE, statute book rules, online sites. We've talked study strategies, planning time, continuous revision, the guide textbook activity method. We explored defining family, Blackwell v. Bull, Sefton Holdings, the landmark Fitzpatrick case. We saw the Human Rights Impact Guidance, ECHR Articles 8 and 14, HRA Section 3, Burden and Burden. We clarified what's not in the syllabus. And we got really practical on exam prep format rules and those checklists for problems and essays, plus citing cases like Reed W. accurately.
It really does set the stage comprehensively. It shows family law isn't static, it's dynamic, vital, complex, always engaging with society and relationships. It's tough, but fascinating to study.
It really sounds it. And thinking about that dynamic nature, how the law has already changed around defining family and human rights. Here's a final thought for you, the listener, to mull over as you study. Given how fast society keeps changing, maybe new tech impacting relationships, more global families, different social structures, how might these future shifts continue to challenge family law in England and Wales? What completely new questions might courts and parliament face down the line, building on these themes of evolution we've discussed today?
A good reminder that the law you're learning now is just one point in an ongoing story.
Indeed. And just to reiterate, this deep dive was for educational purposes only, based on University of London materials and brought to you by Sinorbit Academy, Sri Lanka. To all you students starting out in family law, we really hope this has given you a useful and maybe even encouraging head start. Study smart, use the resources, think critically, and truly, good luck with your exams. That's all for this deep dive. See you next time.